It need not necessarily be always in this manner, because there are many definitions that are overlapping and cutting across the definition given in various books. You see, for example, certain cases of which are of 3 years duration, where the punishment is of 3 years duration, is known to be summons cases. 2 years duration summons cases, and if it goes up to 5 or 7 years, it becomes warrant tribal cases. Otherwise, it is a summons case. But this need not be a hard and fast rule. There are cases which are of 10 years punishment, and yet they come within the definition of summons cases. So summons cases usually go for inquiry, and serious offenses where there is cheating or there is murder, and there it goes for investigation. Rape, murder, forgery has to go for investigation, because investigation means and includes inquiry. It has a broader scope and a wider scope. They can inquire. Police or investigating agencies can inquire into the alleged offense, and they can also investigate. Now, investigate would encompass things like collecting material, sending it to handwriting expert, sending to chemical analysis, sending to ballistic investigation, cyber investigation, lots of things. And that would mean and include lots of things that can be done, including chemical analysis and handwriting expert and so on, photographic, this and that and lots of things. So when it goes for investigation, it is under 153. And when it goes for inquiry, it's under 202. There are 4 sections in the CRPC. First, you start with the filing of your complaint under section 200. If the magistrate is satisfied, he either issue process or he adjourns the matter and delays the matter, keeps it back for the purpose of recording evidence from witnesses who may be present at that point in time in the court. Or he could send it for, that will be 202, is send it to police for investigation with a directive. For inquiry under a directive, that this case be inquired into and report be furnished to him by so and so date. Now, if it is of a serious nature, like I said, rape, theft, robbery, forgery, murder, assault, or some other things like that, then it would definitely go for investigation under 156. And suppose police do not, for whatever reason, police fail, neglect, or refuse to accept the complaint when you file a private complaint. When you go to a police station and narrate to them that somebody has assaulted me, or somebody has robbed me, or some sort of cheating or whatever, cheated me by taking my money and giving some false product, or not giving me something in spite of having taken my money for a particular product or service, whatever. When you narrate your grievance to a police officer who's on duty, it is incumbent for him to reduce to writing a complaint under section 154 of the CRPC. If it is cognizable, if it is non-cognizable, it will come under 155 of the CRPC. That is as far as recording the complaint is concerned. Now, the point is under what sections of IPC will he record the complaint. If it is cheating, it will come under 420. If it is forgery, it will come under that section. Rape will come under a specific section. Different sections are there of the IPC for different offenses. But by and large, police, it has been observed, police try to reduce their work. Not only try to reduce their work, they also try to project a good image of themselves in an annual audit, to show that many complaints did not come, and therefore the situation in the country is, or in the state or in the city, is a very congenial situation. It's not so dangerous a situation. They try to show less crime record by not accepting your complaint. That is one of the many reasons. Other reasons are they could possibly be bribed not to take the complaint. Another reason could be they are lethargic or lazy. They don't want to take the complaint, because then they will have to do a lot of work. Not merely take the complaint, search the accused, arrest him, produce him before the honorable learned magistrate, then constantly produce him as and when required, and for a remand, take him for investigation at police station, then send him to judicial custody. Thereafter, if he is released on bail, It should be ensured that he attends the trial as and when the trial starts, then recoveries and all, lots of things are there to be done. Therefore, they try to reduce their work by not taking the complaint. As a result of them, of police not having taken the complaint, people come by way of a private complaint before the court, expecting to get justice on the court. There they file the complaint under section 200, and the prayer for the complaint is to investigate under 156(3). Now, generally, there has been some misconception. Lot of people are in the legal profession are of the opinion that you should first approach the station house officer or the duty officer at any police station and make out your grievance. If he is not inclined to take the complaint, you go to the senior inspector, you approach the senior inspector. If the senior inspector is not inclined, you go to the ACP. Thereafter, you approach the DCP, and you go up the hierarchy. Go on complaining to various superior officers. And when you have exhausted all your opportunities of complaining to the various hierarchy and you have no other option, then you approach the magistrate. Somehow or the other, I find this to be a total misconception. But this is gaining ground that you have to first exhaust. This concept is gaining ground, erroneously gaining ground, that you have to first exhaust all the options of complaining to various authorities, various ranks of police officers, from duty officer to senior inspector to ACP to DCP to additional and then to commissioner CP. Is it mandatory that I should go through this rigmarole or through this procedure of complaining through everybody right through the hierarchy? In my humble opinion, there is no such thing. There is no such provision in law. The provision is that you should complain, and the complaint should be reduced to writing. If the complaint is not reduced to writing, you have another option to approach the court. But of late, when I say late, I mean around 10 or 15 years in the past, 10 to 15 years in the past, I have been observing magistrates also are inclined not to accept the complaint. And the reason assigned by them not to accept the complaint is you have not tried to complain to ACP. You have not attempted to complain to the DCP. Had you made these attempts and had your grievance been solved, there would be no necessity for you to come before this court. My question paramount is, show me the provision in law. Show me the provision in any law book that mandates that I essentially have to go from duty officer to ACP to DCP to additional, going about complaining, and only when it is finally declined that I am entitled to appear before the court. It is optional. So why do they insist on complaint being on complaint? Because this practice has been going on and had been created by advocates themselves. These are bad practices that have been inculcated over a period of time, sometimes due to the games that people play in the profession and sometimes out of ignorance. Now, if a particular advocate is ignorant of law, that is his problem. The law doesn't change. The law is the law and you cannot travel beyond the law. In fact, it would be correct to say even the court cannot travel beyond the law. The magistrates and judges are bound to function within the law. Of course, certain courts do have flexibility. They have excess powers. They have inherent powers. But those are courts such as the High Court and the Supreme Court. Subordinate courts do not have those powers. The High Court has a power under 482 or 483, which corresponds to 151 or 153. 483 would be in the criminal jurisdiction, which corresponds in the civil jurisdiction. Also, they have inherent powers. But now we are not on the civil side. We are on. Let us confine ourselves only to criminal. High Court also has in its extraordinary jurisdiction powers under writs. So there you have 226 and 227. The Supreme Court also has inherent powers under 34. These powers are vested with certain powers are vested with the High Court and Supreme Court, wherein they can do certain acts in breach of law. I mean, in breach of a statute. They are not legally obligated to confine themselves only to the statute. They can travel beyond the statute to an extent, but by giving a detailed explanation and written, by giving a detailed explanation, by giving a speaking order, so to say, as to how they come to arrive at this and why they think it fit to take recourse to this or take so motive cognizance and move something and amend something. And of course, they are vested with powers and they utilize the power at times, which then comes to be known as case law. Now, coming back to our 156 tree, let us take a case. I'll point out a particular case over here of one Mr. Uh, Dr. Jaiswal. I'll not tell you his name. Dr. Jaiswal versus some Pathak. Okay, Pathak is the accused and Dr. Jaiswal is the complainant. The facts of the case are such, and the complaint is under section 200 for offences under section 415, 420, 506, part 2 of the IPC. So here, the doctor is a medical practitioner by profession, etc., etc., residing in a particular jurisdiction of the court, which comes under the administrative jurisdiction of the court. The doctor says during the court, it is a averment of the doctor that in his complaint that he got to know the accused by virtue of being in the profession, since the accused also is conducting laboratory, etc., etc. That the doctor that the accused befriended him and won his confidence through misrepresentation with the intention of committing fraud and cheating, which at that time the doctor did not understand and doctor did not suspect any ulterior. Then he says that then in another paragraph he says that the the accused approached him and borrowed a certain amount of money because by then they had developed very good business relationship by virtue of the accused having a laboratory and the doctor doing his medical profession. Again, he says in another paragraph, then this money was utilized by the accused who promised to return the same, and for reasons best known to the accused, he failed, neglected, and finally refused to reimburse or refund the monies. So thereafter, the doctor says that by refusing to give them to return his monies, he sent a notice which was received by the accused, but the accused again refused to give the monies and challenged the recovery of the money. So now here the doctor approaches the police, that is Mira Road Police Station. Okay, police refused to take the complaint. They merely made out an NC and said you could approach the court. The doctor also approached the DY the DYSP, because in Mofussil you have DYSP and in city you have DCP. So he approached the DYSP, who again did not take cognizance of. Nevertheless, he received the complaint and acknowledged it. Now, this matter eventually was not taken cognizance of by police. So now the doctor wanted his money to be recovered. So he approached an advocate. The advocate drafted a complaint and asked another advocate to appear because the other advocate was practicing in that group of courts at Thane. His office is located just adjacent to the court, and it would be convenient to engage that advocate because because of various other factors that he could appear on time and it is convenient to. It did not involve a lot of travel and things like that. But as you know, in this profession, there is more of mischief and more of pride rather and less of academic work. So the other advocate said, I'm not going to accept this complaint until I make some changes in the complaint. The advocate who had brought the work to him said, okay, make whatever changes you think fit and proper so that it becomes compatible for you to file the complaint and convenient for you to conduct the proceedings. The advocate who taken over the work deleted certain aspects of the complaint, certain paragraphs of the complaint wherein the complainant had approached the DYSP, and he only included the complaint at Mira Road Police Station. Now, when this complaint was filed and numbered and came up for argument for issue of process, first question that the magistrate asked, why why have you come before this court to recover money when you have only made one complaint to Mira Road Police Station? Why don't you go to the ACP, DCP, etc.? So this advocate had no answer. Actually, this advocate who had taken over the work was more interested in settling scores with the magistrate rather than getting justice for his client or getting justice in general, because they are more interested in politics rather than in obtaining justice. So he went on arguing with the honorable learned magistrate to his own disadvantage and to the disadvantage of his client, wherein the magistrate said, I am not accepting this under 156(3). I will send it under 202. You tell your client to conduct to do verification on this. Because if a complaint goes under 156(3), it doesn't go under, it's not verified. And if it goes under 202, it need to be verified. So now the matter was slated for verification. Had this advocate taken up the matter, who had subsequently taken up the matter, had he retained both those paragraphs, wherein first complaint was given to Mira Road Police Station, thereafter complaint was given to DYSP of that area, and one DYSP's office covers 4 or 5 police stations. So we could have wriggled out ourselves by saying that 2 attempts were made, one at the police station and one at the DYSP's office. Because if it does not fit in, if it does not fit at that police station for want of area jurisdiction or otherwise for any other reason, it definitely is the second complaint would have assisted and facilitated the admission of this complaint at the court. So, by doing such things, the advocate has done disservice to his own client. It should be application of mind. You see, you are there to represent your client and to obtain justice, not to play games. Now, that complaint which was taken up has not been process has not been issued up to date. It has been adjourned because of COVID. Then it was adjourned because magistrate was absent. Now it is adjourned because the complainant is not in a position to attend on a particular date, as he is a medical doctor and needs to undertake various. So for a host of reasons, that matter is pending for over a year. Why? This is the reason. Had the advocate not played these games, that matter would have been either process would have been issued, summons would have come out for the accused, warrants would have been drawn out. By now, the accused would have been before the court. The trial would have proceeded. But the whole concept of 156(3) is, to my mind, it appears to be a misconception. Where from do you get this ingredient? In which part of the book is written that you need to approach a ACP, DCP, CP, additional CP, CP, etc.? And then and only then will your complaint be admitted by a court. Because the language employed in the section, 1 minute, give me that, yes, let me pause for a minute over here. It says, because there it is optional, yeah, there it is optional. You either give your complaint to a police. If the police fail to take the complaint, you can come to the court. You have 2 options. It doesn't say that you have to essentially try to convince the police, and after it has been all options have been exhausted, then and then only your complaint will be admitted before a court. Now here the magistrate are making people handicapped by saying, first you exhaust that. Why should I exhaust that when there exists a provision in law? If there are 2 options, which option to select is my discretion. If I have an illness and I have two options of two drugs. Which drug take is my discretion. If there are two options in law that I can adopt, either go to police or either come to court, I prefer to come to court. Why should I ever go to police in the first place? Who's laying down the law? The magistrate? Is the magistrate competent to lay down the law? Of course, judicial power exists. Judicial power exists to the extent that High Courts and Supreme Court has power to do things beyond law. But magistrate and session court are bound by doing things within a statute. They cannot traverse beyond the statute. And how as to how may and or it should be interpreted, that is well settled law. You may do this or you may do that. May means when the word may is used, how it is to be interpreted, that is well settled law as far as the legal fraternity is concerned. Everybody knows about it. So the section is you may complain to police or you may come to the court, and or may or you have these options in law. So where from have they innovated this impediment, artificial impediment, by saying I won't accept the complaint unless you go back to the police, give the complaint, make a second attempt to give the complaint to a higher authority. If he declines, go to a third higher authority and then come to the court. My question is, where from does the magistrate acquire this section? Is he innovating his own law, which is not empowered to do? Does he have the mandate? Does he have the authority? It is because of the tolerance by ignorant advocates and certain advocates who want to curry flavor with a particular judicial officer, and they tolerate all these patent illegalities, that the quality of advocacy is decreasing. Hello, Mr. Sharma ji. Hello, Mr. Sharma ji. Hello. Can you hear me, Sharma ji? It's not available. I think they're not available. They cut it up. I can hear you. Yeah. He's not replying.
Hello. हाँ सर
Can
कंटिन्यू
you
कीजिए
hear me?
कंटिन्यू कीजिए. Yes.
So, can you take question answers? If somebody might be wanting to ask something in between.
Just a second, sir. I will check. Sir, there is no any question, sir.
No questions.
No,
So
no, sir.
either everybody has understood or nobody has. Either they understood everything or not understood anything. Or am I too fast? Or is my voice not properly modulated?
Yes, sir. आपका आवाज ठीक आ रहा है, sir.
ठीक आ रहा है?
Yes. Continue,
Okay.
sir.
So these are the bad practices of wherein we are encouraging and we are spoiling the judiciary. We ourselves are instrumental in spoiling the procedure by introducing or by tolerating things that are not permissible in law. It is necessary for advocates to come together and brainstorm themselves, have academic sessions and deliberate on the subject of 156(3) as to why and how, who introduced this and why is it continuing. 156(3), I'll read it out to you. 56(3). Yeah. Police officers' powers to investigate cognizable cases. Any officer in charge of a police station may, comma, without the order of a magistrate, comma, investigate any cognizable case which a court having jurisdiction over the local area within the limits of such station would have power to inquire into or try under the provisions of chapter 13. That is 156. 1. Now we come to 156.2, that's subclause 2. No proceeding of a police officer in such case shall at any stage be called in question on the ground that the case was one which such officer was not empowered under the section to investigate. Then we come to 3, subclause 3 of 156. Any magistrate empowered under section 190 may order such an investigation as above mentioned. Okay. In any of the three, in any of the in this section, any of the 3 subsections, there is not a whisper that we have to first approach a police station, or for that matter, approach a police station and try to obtain redressal at the lowest level, that is the duty officer at a particular police station. If not him, the office of the ACP. If not him, the office of the DCP, or else additional. There is not a whisper in the bare act that says that we have to essentially do these acts and then approach the court. It is very clear. Any magistrate empowered under section 190 may order such an investigation as above mentioned. So for that matter, what prevents anybody from going to court? If you go to court under section 190 or whether you go to court under section 200 as a private complaint, it is one and the same thing. 190 is anonymous, where any party, any person can set the criminal law in motion, even though you have no locus standi, because save and except in certain cases, defamation, adultery, and certain cases where only person aggrieved or person related to person aggrieved can complain. But otherwise, criminal law can be set in motion by just about anybody. The question of locus standi does not arise, save and except certain sections which have been explicitly barred and for which there is a mention in law books. Of course, there are state amendments. State amendment in Maharashtra, in its application to the state of Maharashtra in section 151, in the subsection 2, after the was required or authorized, insert under sections, notwithstanding anything contained in this code or any other law for the time being in force, with the magistrate for whom such person has produced reasonable grounds of temporary detention. Yeah. 151, that is 151, that is 151, criminal. Okay, here we come. What we have? 156, 150. If from the information received or advised, an officer in charge of a police station has reason to suspect the commission of an offence, which he is empowered under section 156 to investigate, he shall forthwith send a report of the same to magistrate empowered to take cognizance of such offence upon a police report, and shall proceed in person or shall depute one of his subordinate officers, not being below the rank of the state government, as the state government may, by general or special order prescribed in this behalf, to proceed to the spot to investigate the facts and circumstances of case, and if necessary, to take measures for the discovery and arrest of the offender. That is 157. So the powers are vested with police to take a complaint if a citizen approaches the police. Powers are also vested with police to take cognizance so moto, irrespective of anybody complaining. If they see any illegality, because one should, in order to arrive at the essence of a meaning of offense, one should comprehend it in its conglomerative sense and not piecemeal. Now, if you look at offense has been defined differently in different acts. And in order to arrive at the essence of offense, you should try and understand offense from Cr.P.C to IPC to Bombay Police Act and the manual and everything. Look at all the acts and all the rules in order to arrive at the essence of the meaning of offense. And when offense has been understood in its conglomerative sense, then it has a broader spectrum. It has a broader base. So if a person has committed an offense which comes to the knowledge of a police officer, he need not receive a complaint. He can proceed on his own. He can file a FIR on his own. And he can also file an FIR if a person comes as a complainant, which strictly speaking, we say complainant in layman's language. Actually, it's an informant. You are informing the police officer. In legal language, you are informing the police officer, and you are not a complainant, you are an informant. He reduces to writing and the state becomes a complainant. See, then there is another mode of complaining. A complaint can come under 156(3) even from through a magistrate. If you file a private complaint before a magistrate under section 200, it is sent for investigation under 156(3), depending on what the ingredients of the complaint are. If the ingredients of the complaint are such that it is so many years punishment, it is cognizable, it is non-bailable, obviously it will go for investigation and not for inquiry. Because inquiry has a limited scope. Inquiry would be under 202, but nowadays we find magistrates literally playing with the complaints. What ought to go under 156(3), magistrates have the audacity to say in an open court, tell your client to do verification. I'll send this under 202. Or change the section. Or do this. What is to be done, magistrate has no authority to suggest. He is not a legal advisor. He is limited, job is limited to accept the complaint, peruse the complaint, hear the submissions, and pass an appropriate order accordingly. He cannot suggest you remove this section or you do this. If the section is improper, the court is empowered to change the section of its own. Sections are merely suggestive, tentative. The charge that is being brought or the suggestion that have been given by a complainant or whoever are merely suggestive. It is not, the court is not bound to go by that suggestion. The court may, of its own accord, change the section. The court is vested with power to change the section. What prevents the magistrate from changing the section? So he can change. He need not tell you or need not ask you to do anything or need not ask you to change the sections. He can do it of his own. If he feels that this cannot go under 156(3), he can send it for 202. But then the ingredients of the complaint should be such that going under 202 will not breach any law. But there are times when complaint is a serious complaint, assault, theft, robbery, which in the normal course ought to go for investigation under 156(3), forgery, etc. Yet magistrates are inclined today to say, tell your client to do verification. I will accept this complaint under 202. I fail to figure out as to under what provision of law they suggest. Judges are not to suggest, judges are to be neutral and adjudicate judiciously what comes before them. So I'll pause here and stop now for any clarifications that the audience may want, and if it is possible for me to, because I'm not necessarily the most learned, I may have my shortcomings as well, but I'll make an attempt to answer to the best of my ability. A lot of people say that you should go according to case law. The case law says this. The case law says that we should use this case law to strengthen our complaint so that the matter goes under 156(3). When they file a complaint, sometimes people use various case law, High Court case law, Supreme Court case law, etc. That is favoring them. Case laws are of both types. Some case laws are against you, some case laws are in favor of you. which to select. That is the game. That learned people in the profession know which to select, which to highlight, and what to conceal. The whole profession is based on this. Your expertise rather is based on this. In fact, if you're for prosecution or for defense, depending. So there are a number of case laws of various states, and there are case laws of the Supreme Court. Supreme Court case law is a binding on all subordinate courts. That will mean and include all high courts of all states in our country. As per Article 141, it is binding. But the question is, why use case law when the statute itself is clear? Why should I take the aid of case law? Because ever since India got independence up to today, this many years, so many cases have been disposed of, and so many case laws have come into existence. And the volume of case laws is the compilation of case laws is growing and growing and growing. So there should be a cut-off date. Otherwise, somebody will use some case law which is 20 years back and was to his advantage. Somebody might use a case law which is only recently or to his advantage or disadvantage of somebody else. So this is creating chaos. Why should we take recourse to case law? Case laws, what is the case law today at the time of filing a case? So you might select a case law that is supporting your case. You will select a case law that you prefer to rely upon, and the magistrate will appreciate your case law, or magistrate or judge will appreciate your case law and possibly issue process. But the question is, this case law that you are using today may become obsolete in a month or in a week, or for that matter, it may become obsolete tomorrow. A time may come when one case law is cited in the morning to support your case under 156(3). And by evening, you might receive another case law that becomes case law for the land, which will be opposite to that case law that you cited in the morning. In such a scenario, what do you do? Not to place much reliance on case law. Rely on the statute and take very little help of the case law, whichever, for 156(3) or anything. So that is all I wanted to say. Now I'll end my webinar with thank you to C.A. Prabhu, the housing guru, Sharma ji, and all at MahaSeWA Housing. Thank you very much. Thank you, audience, as well.
For all services relating to transfer of flats, stamp duty, registration of documents, recovery of dues, RERA, MOFA, and important subjects like redevelopment and self-redevelopment of cooperative housing societies, you can always rely on MahaSeWA and Prabhu Associates for the best legal advice. You may reach us on our customer care number 022 4255 1414 for any assistance.